I don't know if you can see my delinquents back here or not. They're all cozied up on the couch together. Geeky dogs. So I have another PowerPoint presentation for you guys, okay? So, um, and again, I want to say thank you to all of you who are haters, but you aggressively stalk my YouTube channel and increase my number of views. Because, I mean, I'm up to like 40-some thousand now, and I'm just a stupid blonde girl from Kansas City in the Midwest, you know? According to my ex today, I say, "You're crazy, you're stupid, I never said that, I never did that." It's called gaslighting. Anyway, um, so this is about appellate trends and appellate rulings in the Missouri appeals courts, okay? Appeals courts. That's what they're there for, too. You know, the system of checks and balances that exists in America. And look, I got a little laser pointer this time. So, insufficient, insufficiency of emotional distress. Because people always claim they're under emotional distress when, come on. Yeah, right. The Court of Appeals has repeatedly vacated orders where petitioners merely alleged they were startled or bothered, but failed to prove substantial emotional distress as defined by Missouri Revised Statute 455.0101E. Okay? Go. Why isn't it going? Oh, next slide. Here we go. Rejection of domestic conflict as stalking. Okay? Judges are increasingly distinguishing between difficult interpersonal relationships and the legal definition of stalking. If a respondent's actions, like contacting an ex-partner or during a family argument, or like this one time when I needed help with my door handle, and Damien was out there helping me, and somebody called the police on both of us, yeah. For him helping me with my door handle on a public street. Anyway, can be tied to a legitimate purpose or lack a threat of physical harm. The court is likely to find that order unwarranted. Right. So the stigma and the misuse. Now, I don't care about stigma. I don't care. I don't care what people think about it. I'm not worried about it. But the appellate courts have noted the stigma attached to these orders, which can label individuals as abusers or trackers on public databases like CaseNet, making the scrutiny of evidence even more critical. So they should probably be scrutinizing the evidence a little bit more, you know, like maybe taking it all into account, but they don't because the courts are corrupt too. I know that for a fact. I've been through it all 80 times. Not 80, but it's called the Dekoff over-exaggeration factor in my family. But this is an excerpt from one of the appeals court's rulings. Missouri's Adult Abuse Act was not designed to resolve minor arguments between adults. Grown people, you know, people that are like over 18. I know some people out there who are grown still act like children, but it's time to grow up, folks. So there exists great potential for abuse of the act. Wow, imagine that. Like, you know, people who put disabled people out of their houses just so they can take it over because they're mad about them not letting them use their car, or, you know, people in like breaking up or getting a divorce and they use it to like steal all the assets real quick, you know, go get an ex parte against somebody, empty the house out. Yeah, I've seen that a bunch of times too. However, I have seen it used for the legitimate purpose it was intended for when it originally started under the Violence Against Women's Act of 1994 for like women and children who are beaten and bloody with nothing but the clothes on their backs. Yeah, that's what this was for, not for jackasses, okay? Jackass lying crybabies. It's not what it's for. So as the appeals court has said, there exists great potential for abuse of the acts, and real harm can result from its improper use, including the shame, like I said, I don't have any shame, that may attach to the respondent who is ultimately labeled a stalker for driving on public streets and whatever. Thus, courts must be certain that sufficient credible evidence from credible people supports all elements required for a protective order. That's why these cases keep getting reversed and kicked back. Thank you. Next slide. So, the term substantial emotional distress, okay? Now, come on, emotional distress requires that the offending conduct must produce a considerable or significant amount of emotional distress in a reasonable person. Well, these people aren't reasonable, though. Something markedly greater than the level of uneasiness, nervousness, unhappiness, or the like, which are commonly experienced in day-to-day living, especially in the times we're living in right now, right, people? Like, it's all the way effed up out here, okay? We all know, unless you're one of the elite minorities or you have special privileges because, you know, there's corruption out there. So, yeah, it's just great, ain't it? I know. So, next slide. The term, wait, go. Oh, sorry, this is different to me because I put it in a different format. Reminder. This is a reminder, though, for everybody about what the appeals court says. The Missouri Appeals Court, you know, the checks and balances that oversees the circuit courts. Yeah, that one. Okay. The remainder of the incidents described by RK, this is in this one case, was talking about that they reversed. Kelly's use of obscene language and hand gestures directed at RK, but there was no evidence that those incidents caused RK to fear physical harm. Now, if somebody flips me off and cusses at me, I'm not going to be in fear of physical harm. And I'm a 5'4", 145-pound female, okay? But allegedly, you know, other individuals twice my size are scared if someone my size flips them off and cusses at them. If you're that scared of someone like that, people out there, you might want to evaluate that or maybe get some therapy. I don't know. But we all know that's a lie. Come on. Okay, so, but so then it also says the appellant's use of a rude hand gesture while vulgar and boorish was insufficient to support a finding of subjective alarm. Testimony about harassing text messages driving by appellant's place of employment and flipping appellant off that only caused irritation and inconvenience but not fear of danger of physical harm was insufficient to prove stalking. So, basically what the appeals court was saying that, you know, if somebody's done some jackass things to you and you happen to see him, you know, you're driving around, whatever, and you flip them off and tell them to fuck off, that's not putting them in danger of physical harm. It's insufficient to prove stalking. Okay? So that's what the appeals court has said in recent case law. So, I just wanted to put that out there for everybody who, you know, those of you out there who are offended or crybabies or think you can abuse the system. You can't. That's why we have checks and balances in America. So we have 3 branches of government, and they all have systems of checks and balances in place to balance and check on each other to make sure that one or the other is not fucking up. Now, we all know that it's seriously messed up out here still, but I had this really great book, actually, that talks about why America has never been overtaken by a dictatorship or communism or socialism. It's due to the system of checks and balances that our founding fathers put in place. They literally turn over in their graves, I'm certain, if they saw what goes on today. So, that is my presentation about the Missouri Appeals Court recent rulings. And coming to my channel here soon will be more facts and blunt speech about facts. Thank you!